Hi, and welcome to this latest immigration law update video. Today, I'm starting a new series looking at the Upper Tribunal Immigration and Asylum Chamber reported decisions for 2020. And I'm going to take them a month at a time. So in each video, I'll look at the reported decisions for a different month of 2020. And today I'm starting with the reported decisions for January 2020. On the slides, I've put the head note, but in the description below, there's the links for the video. And I've also set out the full head note below if you want to cut and paste them into any of your representations. So the reported decisions for January 2020 cover a number of subjects. There's accountants' evidence in tax discrepancy cases. There's issues of permission to appeal. And there's also two cases on the relevance of British citizen children, one in the context of deportation and one in the context of entry clearance. So let's have a look at some of the decisions. The first one is the case of Abbasi, and it's Rule 43, paragraph 3225, accountants' evidence, Pakistan, 2020, UK, UT 27, and it was from the 8th of January this year. And this concerns a refusal of indefinite leave to remain with a refusal under the general grounds relying on 3225. This involves tax discrepancies, and I'm sure practitioners are aware of these cases, but the leading case is the Court of Appeal decision in Balajagari. And in this appeal, the appellant had two tax returns in which there were discrepancies with the applications to the Home Office. They were 2010-11 and 2012-13. The appeal came before the first tier tribunal, who allowed it, relying on a letter from tax assist accountants, who were a franchise of accountants, and they accepted fault for the error. This came before the Upper Tribunal, and the Deputy Upper Tribunal judge set aside the decision of the first tier tribunal, finding that the first tier tribunal hadn't properly assessed the claim, but then went on to rehear the case and allow it, again relying on that letter. Now, after the allowed decision, the Upper Tribunal were emailed by tax assist accountants, and effectively it became known that that letter was a fraud. It was a fake. It wasn't a genuine letter. So the Upper Tribunal reconvened the hearing to look at their powers to set aside the decision of the Upper Tribunal. So it was looking at Rule 43 of the Upper Tribunal Procedure rules, which is a power to set aside a decision which disposes of proceedings. So the Upper Tribunal held that Rule 43 can be used of the tribunal's own motion, and that actually a fraud, which this letter was, constitutes an abuse of process, and that can amount to a procedural irregularity, allowing Rule 43(2)(d) to be used. Now, actually, by the time the case came before the Upper Tribunal, the appellant had been granted leave to remain. So the appeal actually ceased to exist and had been treated as abandoned. So actually this was all academic, and it was a matter now for the Home Office what to do about his leave. But the Upper Tribunal went on to give some guidance on the use of accountants' evidence in appeals, and it's covered in the decision in paragraphs 63 and 64. But let's have a look at the summary in the head note, which is on the screen. In a case involving a decision under paragraph 3225 of the immigration rules, where an individual relies on an accountant's letter admitting fault in the submission of incorrect tax returns to HMRC, the FTT or the UT is unlikely to place any material weight on that letter if the accountant does not attend the hearing to give evidence by reference to a statement of truth that explains in detail, notice the in detail there, the circumstances in which the error came to be made, the basis and nature of any compensation, and whether the firm's insurers and or any relevant regulatory body have been informed. This is particularly so where the letter is clearly perfunctory in nature. So from now on, you're not going to get very far just relying on a bold, brief accountant's letter. Really, the accountants going to need to come and give detailed evidence in those circumstances. So that's Abbasi. Let's move on to the second case, which is OK, and that's PTA, Alternative Findings, Ukraine, 2020, UKUT 44. And this concerned an asylum seeker from Ukraine who feared persecution as a draft evader. The first-tier tribunal judge dismissed her appeal, finding, on credibility grounds, finding that she wouldn't be actually called up, so she wouldn't be a draft evader. But the judge went on to make an alternative finding that even if she was called up and treated as a draft evader, she wouldn't suffer persecution. Now, grounds were drafted, and they were very detailed grounds. Apparently, there were 7 grounds in all for permission to appeal to the Upper Tribunal, and permission was secured. But the one thing the grounds did not do was challenge that alternative finding of the judge, that even if she was called up, she wouldn't be subject to persecution. So the Upper Tribunal are quite critical of this, and they're critical of the grounds. In paragraph 15, they remind representatives that grounds should be drafted with the appropriate degree of particularity and legibility. So we need to be legible and particular when we draft our grounds. And permission shouldn't be granted if there's an unchallenged alternative basis for the appeal. So look at paragraph 16. We observe that when considering applications for permission to appeal to this tribunal, judges must give careful consideration to whether there is any meritorious challenge to the alternative basis for refusing or allowing an appeal, as the absence of such challenge will normally be determinative as to the prospect of success. So obviously this case reminds us in terms of drafting grounds that we should be very specific and clear in our challenges, but we should also look out for alternative findings, because if we don't challenge them, any other challenge is bound to fail. Let's move on to the 2 cases then concerning British children, and they're quite tough cases. And perhaps we see the panel, which is the same panel in both, who heard the cases on the same day, really just watering down a bit the power of having British citizen children. The first one is in the context of deportation and the unduly harsh question. Now, we know following KO Nigeria that when considering whether it's unduly harsh for somebody with children to be, qualifying children to be deported, the focus is on the children alone. But that unduly harsh threshold is a high threshold, and we need something more than just separation from a parent who you have a loving, caring relationship with. Look at the 2 Court of Appeal cases, PG Jamaica and KF Nigeria, both from 2019. This case concerned an Indian national who got 3 years, 6 months imprisonment for money laundering offences. He had a British wife and son. The son was born in April 2013. So it was an under 4-year sentence. So the unduly harsh provisions bit in this case. And it was a British child, so the child was a qualifying child. So let's have a look what the Upper Tribunal did. Now, the first thing they looked at is the slight different wording between section 117C5 and 399A Roman 2 of the immigration rules. Look at head note 1 here, because 399A2 looks at these 2 questions of whether it would be unduly harsh to leave with the parent, or it would be unduly harsh to remain without the parent who is deported. Whereas 117C5 just says, well, the effect of deportation would be unduly harsh. The Upper Tribunal says, look, there is no difference between those provisions. They're the same considerations, and the tribunal must look at the 2 questions of whether it would be unduly harsh to leave with or unduly harsh to remain without. Then they go on to look at the assessment of undue harshness and say in head note 2 that decision makers are asking a hypothetical question, whether going or staying would be unduly harsh. They're not predicting whether the child would actually go. In terms of nationality, in the form of British citizenship, that is a relevant factor in the unduly harsh assessment, but it's not necessarily a weighty factor, and all depends on the actual facts. And the possession of British citizenship by a child with whom a person has a genuine and subsisting parental relationship does not mean that the person is exempted from the unduly harsh requirement. Even though the child may be British, it has to be unduly harsh both for him or her to leave with P or stay without P, not just harsh. Thus, some substantial interference with the rights and expectations that come with being British is possible without the position becoming one of undue harshness to the child. So just because you've got a British child doesn't mean you're exempt, and you still have to show that something more. You can have an acceptable level of harshness, even with British children, when it comes to deportation. Let's look at the final case, which is the one on entry clearance and British children. In this case, it was a spouse application from Sri Lanka. There were two British children born on January 13 and April 15, and they lived with the parent in Sri Lanka, the parent who was seeking entry clearance. Just of note, these kids in this case were dual nationals. The appeal was dismissed, but that was set aside by the Upper Tribunal on the basis that the interests of the British children who live abroad with the parent had not been properly weighed in the consideration. Now, it was accepted that Appendix FM couldn't be met in this case. So it was really looking at the rights of the children in the Article 8 balance. So what did the Upper Tribunal say? Well, British citizenship is a relevant factor. Notice the word there, relevant factor, when assessing the best interests of the child. And here's the positive stuff too. British citizenship includes the opportunities for children to live in the UK, receive free education, have full access to healthcare and welfare provision, and participate in the life of their local community as they grow up. So that's the positive stuff to emphasize in cases. Then 3, there is no equivalent provision to section 117B6. That's the reasonableness test for in-country cases of the Nationality, Immigration and Asylum Act 2002 in any provisional law or policy relating to entry clearance applicants. So you can't just apply the 117B6 test in entry clearance cases. 4, in assessing whether the refusal to grant a parent entry clearance to join a partner has unjustifiably harsh consequences, so that's the Article 8 proportionality assessment, the fact that such a parent has a child living with him or her who has British citizenship is a relevant factor. However, the weight to be accorded to such a factor will depend heavily on the particular circumstances and is not necessarily a powerful factor. So you can't just use it as a trump card. You've got to address the particular facts of the case and why, in this case, the British citizenship of the child is a significant factor in rendering the decision unjustifiably harsh. And then 5, when assessing the significance to be attached to a parent's child having British citizenship, it will also be relevant to consider whether that child possesses dual nationality and what rights and benefits attach to that other nationality. In this case, they had also Sri Lankan nationality, and the evidence were that their needs were being met. They had education. So those were significant factors in the Article 8 assessment. I hope that's helpful in summarizing the reported decisions from January 2020. In the next video in this series, I'll look at the decisions from February 2020. I've put my contact details on the screen if anybody needs to know more, and I hope that's helpful. Thanks very much.